at the top of the hour here, and I'm excited to get this conversation going. Welcome everyone. Today we have two incredible guests. We have Mike Tetreau as well as Harry Barth. We're going to hear a little bit from both of them today, but I'm excited to have this conversation as we talk about the Corporate Transparency Act. We have Mike, who is coming to us from Connecticut, where he is a Vistage Chair, and he is in with the CEOs. He knows what the pulse is of businesses in his location. I'm excited to hear from him. And then Harry Barth, who comes to us from Barth Calderon. That's an asset protection, estate planning, and business planning law firm located in Orange County, California, with clients nationwide, where he leads the team there and leads in webinars nationwide as well. So before we hear from Harry about the Corporate Transparency Act, I want to hear from you, Mike. Tell us about what you're doing there in Connecticut. Tell us about the leaders you work with.
Helen, thank you. And thank you for being here. And Harry, it's great to join you today. Looking
Good,
forward
good
to
to
your
be with you
presentation.
again, Mike. Always.
My members are very excited about this. As a Vistage chair or coach or facilitator, I lead a Vistage group of CEOs that run small to mid-sized businesses. They're in manufacturing, software and technology, publishing, retail, finance, and insurance. But importantly, all the members in a Vistage group are from non-competing companies. So it allows for very open conversations. Everybody's allowed to be very vulnerable to the group. And that's where you get the real leadership development from, the real engagement, and provides a great experience for everybody. And my members are really excited to hear what Harry has to say, because this is going to impact a number of them, their companies, and their other legal entities. So thank you for inviting me to join you today.
Too. And Harry, before we jump in, I see we have a couple of attendees on our webinar today, and I want to invite you to leave questions in the chat or the Q&A section as they come up. We're going to give a little time for Harry to go over questions at the end. But Harry, this Corporate Transparency Act, tell us about it. What do we need to know?
Okay, well, there's a lot we need to know, actually. And surprisingly, it's a critically important act that not as many people know about that should. The government has done a horrible job in bringing this out to the constituency, and especially since there's such draconian penalties associated with not complying, it's kind of weird. But it is what it is. So today, hopefully, everybody who's with us or who'll hear this will have a much better picture of what it takes to comply with the Corporate Transparency Act. Well, first of all, what is it? It was a bipartisan legislation that was passed in 2021, and the purpose of it is to compile a non-public list of who are the human owners of entities. So to help prevent terrorist financing, money laundering, and tax evasion. So the Corporate Transparency Act registry is primarily and typically only used for law enforcement purposes. So important to understand the Corporate Transparency Act. It applies to every single entity in the United States of America, just not new entities, but all pre-existing entities, unless they are exempt. That means all LLCs, all corporations, all limited partnerships. So if you have to go to the Secretary of State's office and have an entity, you get a charter or articles of organization or articles of incorporation from the Secretary of State, that entity is an entity, unless exempted, needs to comply with the Corporate Transparency Act. Now, I'm going to be using a term today that you may or may not be familiar with. It's called FinCEN. FinCEN is the Financial Crimes Enforcement Network, and it's a subdivision of the United States Department of Treasury, and it is the agency that's been tasked with enforcing and enabling the Corporate Transparency Act. Is the government serious about it? But before whether the government's serious about it, are there some challenges to this act? The answer is yes. So there are two challenges that are floating around now in the judicial sphere. One of them is the National Small Business Association versus Yellen, which was a case that was heard in the Northern District of Alabama. In that case, the judge issued a summary judgment that said that the Corporate Transparency Act was unconstitutional. And he said it was unconstitutional because Congress did not have the power to pass the Corporate Transparency Act. It wasn't within congressional authority to do so. Um, that that decision only applies to members of the National Small Business Association who do not currently need to comply. Everybody else in the country, 33 million of us, have to comply. Also, it needs to be known that the United States government has appealed that decision by that judge. And based upon my 50 years of experience, more likely than not, that judge will be overruled and the Corporate Transparency Act will be in full force. We do not expect the 11th Circuit Court of Appeals or the any other district or Supreme Court to overturn the Corporate Transparency Act. The other case is Boyle versus Yellen's up in Maine, just getting going. And in that particular case, also questions the constitutionality of the Corporate Transparency Act, because there the gravamen or the center of that case is that the regulation of businesses, corporations, limited partnerships, LLCs, is to remain with the states, and the government, the federal government, should have no impact on the state's rights to regulate its businesses within the state. Okay, give that time. So is the government serious about this? So let's talk a little bit about penalties for failure to comply. Really important. So first off, you'll learn about the dates for compliance that we have to comply by. If we're not in compliance by a specified date, then, and we'll see who needs to comply, it's a $591 a day fine without a cap per violation. If you got a few entities and they're not in compliance and they're 10 days off, $15,000, $20,000 worth of fines, like boom, just like that. In addition to that 591-day failure to comply penalty with no cap, there are also criminal penalties associated with willingly failure to comply. There's a $10,000 criminal fine and up to 2 years in jail. It's a felony. And this is all being enforced by our lovely friends at the Internal Revenue Service to collect the fine. So they are serious about this act. You'll note that I didn't say that trusts were subject to the act. They're not, but if a trust, you'll learn, holds a certain amount of a entity that needs to comply, then the trust needs to comply. And I'll take you through examples of how that works. So very important, the Corporate Transparency Act registry is not public. All right. So if one formed for asset protection purposes or estate planning purposes, a entity in Wyoming that does not publish who the managers and members are, this does not make it public. This is only for law enforcement use. And we need to understand the basis of what's behind this thing. What's behind it? What's the driving force? Of course, it was 9/11, terrorist financing, and all. The purposes are noble, but the main thing is to find out who are the human beings behind the entity. We had the Pandora Papers, we had the Panama Papers, we have sometimes even our own president that has 18 shell companies. They want to know who are the people behind it, and it's very important to understand that. If Mike, we just have Blue Ocean LLC, they want to know who are the owners of Blue Ocean LLC, who controls Blue Ocean LLC, and I'll take you through examples of that. But let's go one step to a very important component for Mike, for you and your constituency and everybody listening, who's exempt, who does not have to comply. And this is a very interesting part of the Corporate Transparency Act. So let's walk through who does not need to comply. So big public companies don't need to comply. So if they're listed on the New York Stock Exchange, American Stock Exchange, NASDAQ, they don't need to comply. Why don't they need to comply? Because these organizations, including the SEC, are all over who the board is and who the CEOs are. They know who they are. They know their background. They know their fingerprints. They know everything about them. They have to have a disclosure, so they know who's running GM. Not a question of, there's not some dark veil of who's running General Motors. So they know that. So public companies don't need to comply. SEC registered investment advisors, investment advisory firms, for the same reason, The investment advisors are regulated by the Securities and Exchange Commission. Their backgrounds and everything about them, Mike, are well known, so they don't need to comply, nor do venture capital fund advisors need, for the same exact reasons. Insurance companies, which are highly regulated by the state, insurance producers who are licensed with all their background information, they don't need to comply. We know who they are. Certain other highly regulated financial institutions like trust companies, banks, credit unions, and broker dealers like, JP Morgan, Merrill Lynch, Morgan Stanley, they don't need, all the same reason. We know who they are. We know what they're doing. We have their background. We have their fingerprints. We got their live scans. We know who they are. Public accounting firms, CPA firms that we're able to certify under Sarbanes-Oxley are also registered with the government. We know who they are. We don't have to worry about that. One thing that was interesting that is exempt, the tax-exempt entities. Tax-exempt that nonprofits are exempt from compliance, but that doesn't necessarily mean that nefarious activities may not happen in a alleged nonprofit. It could be the Angels of Mercy, Inc. or but yet somewhere in the Angels of Mercy, maybe some nefarious activities are going. But they're at this point, they're not subject to the Corporate Transparency Act. And we also have, if it's a subsidiary, so if Mike and Harry LLC, which we're going to talk about in a minute, is exempt, then any subsidiary that we own is exempt. Now, what gets people confused is that the subsidiary is not the same as a brother-sister entity, which we'll talk about. I'll use myself as an example for that. But the big exception that affects you, mostly Mike, your Vistage members and others, is what they call the large company exemption. And so the large company exemption, this is an and, not an or. So if the company has 20 or more full-time employees, not contract employees, not part-time employees, full-time employees is defined by like the state of Connecticut, and they have their offices in the United States of America, number two. And number three, they have $5 million of gross sales or more. All right. They are exempt from the act. All right. So, and that affects, I know all about Vistage and Vistage entities. Many Vistage entities are there, but not all. Some of them could have 10 employees and have $20 million worth of revenue, high-tech company, and they're subject to the act. So let's use myself as an example about that. So, for example, Barth Calderon, a law firm. Well, do we have over 20 full-time employees? Check, yes. Our offices in the United States? Check, yes. Do we have over $5 million of gross sales? Check, yes. So Barth Calderon, the law firm, is exempt from filing under the Corporate Transparency Act. However, Harry has 12 other entities that own real estate, entities that own equipment, machinery, intellectual property, investments, other companies that do other things, okay, that I own. Every one of them is subject to the Corporate Transparency Act. So if these are not subsidiaries of Barth Calderon, but for asset protection purposes and estate planning purposes, as most of your members, they may own the building where they have the factory, and they lease it to the company. The company might have 50 employees and $100 million worth of sales, but the building, has no employees and has subject to the act. So those are what we call brother-sister entities. Very important that they comply. So those are the exceptions. So now let's get into the logistics, and we have two different sets of timelines. So we have and this is, it's crazy. We have all the entities that were formed in the United States of America prior to January 1st, 2024. All of those entities that are not exempted, we estimate there are about 33 million of them. And when you see, and their progeny could be close to 200 million, you'll see when we get to the amount of transactions per entity, they need to be registered under the Corporate Transparency Act by December 31st, 2024. Not too far away. Maybe, 8 months from now. How we're going to do that, God only knows. It's almost, I think it's an impossible task, but if we're not registered by December 31st, $591 a day fine for each of our entities and each violation. Horrible. for new entities formed after January 1st, 2024, from the date that the Secretary of State's office in Connecticut says that LLC is born, we have 90 days to bring it into compliance with the Corporate Transparency Act, or the fines begin to accrue. So, as you can see, since the act went into effect January 1st, 2024, it was March 30th, April 1st, for an entity that was formed on January 1st, it's the first ones that are coming up, getting it done. So just in the last 14, 15 days, we can begin to see if any entities are not in compliance. And now when the enforcement begins, all the proverbial poop will hit the fan. Okay, because now they're starting to collect. Okay, so we have that. So what I want to do to help everybody understand the act is, Mike, you and I will form a new entity on April 15th of this year that's going to sell widgets.
I'm ready to sign.
Okay. It'll be Mike and Harry, LLC, the widget company. All right. And we're going to have a couple of DBAs. Widgets are us and widgets are them. All right. And so we formed on April 15th. That tells us we have, well, unless we're exempt, but we're not exempt. We don't have 20 employees. We don't have $5 million gross sales. We have a new entity. So Connecticut gave us our birth certificate on April 15th, and we have 90 days to come into compliance. Okay. What does compliance mean? So the first thing we need to all keep in mind, very important, that the responsible party for reporting the various transactions is our entity, Mike Harry Co. LLC. So we've got to take Mike Harry Co. LLC and we need to register it with the Financial Crimes Enforcement Network website at www.fincen.gov. I think Helen will put it up in the chat in a little while. And we go there and we need to register our entity. So what do we got to do, Mike, to make our entity work? Well, we got to give it its name. You know, it's Mike Harry Co. LLC. We formed it. It was formed on April 15th. We need to give all of our DBAs. Okay, so widgets are us and widgets are them, which makes sense, you know, because that's we're bringing our stuff out. We need to give them our physical address of our company. So where our company headquarters are located. And it's not at the attorney's office, it's not at the accountant's office, it's not the UPS suite, and it's not a post office box. The physical location, if it's virtual, it's our house. We got to give them that number. And then we got to give them a unique identifying number for our entity. Now, when you and I formed it, or when my law firm formed the entity for you and I, we went to the IRS, we got an EIN number, so we give them that EIN number. As we know, there are people that form single member LLCs, and single member LLCs are sometimes disregarded for tax purposes. So we'd have to give them our social security number in order to make that happen. Okay, so now we got our entity is now filed with FinCEN, is now a responsible reporting entity. All right. So now we got to tell them who owns it, right? Which is the whole purpose of the act. So as we started, Mike and Harry are the two 50-50 members of the LLC. So those are now known under the act as BOIs, beneficial owners of interest. And any beneficial owner of interest of greater than 25%, that's not a minor, needs to report the FinCEN. So and they're not reporting individually, the company is reporting its beneficial owners. So Mike and Harry has to report that Mike Tetreau, okay, is now the 50% owner. So Mike, you got to report. So what do you got to say? You got to give him your name. All right, got that. Got to give him your physical home address. Again, no law firms, no post office boxes. And you must give them, send them a PDF, a color PDF copy of your driver's license, unexpired, or your passport. That must go to FinCEN, and that would complete who the 50% owner of our company is. And Harry has to do the same thing. Now, one of the things that little trick, we'll talk about a little trick right now, is Mike, and you should do this. If you go to the FinCEN website, this we can't do for you. A lot of things we could do for you, but this we can't do for you. we'll talk about law firms' impact on this, is you go to FinCEN's website that Helen put up in the chat box, and open up an account there, Mike. So you go open up an account, and they'll want to know, your name. They'll want to know, where you went to elementary school, color of your first dog, all the crap that they go through for authentication, and then two-factor authentication, it is. And then if you give them that information, your name, your address, and the identifying documents, they will issue you, Mike, a FinCEN number. All right. And then every time you have to do a FinCEN disclosure for the corporate transparency, you just put down Mike Tetreau, number so and so and so and so, and you don't have to give your home address and to put your identifying documents every single time. So for me, that I have so many entities and a lot of other things that you're going to learn about, I got my number because it's going to be hundreds of times that I'm going to have to make that disclosure. So we got our two owners, but sadly, it's not just ownership. All right. The Corporate Transparency Act is who controls. So we have to make a determination of who's in control. So let's say we hired Helen Co., all right, to be the manager of our LLC because we liked her glasses. Okay. So Helen Co. is going to be the manager of our LLC. Now, she's not an owner. She's just the manager, and she controls the entity. Mike and Harry are passive in doing this. So because Helen Co. is now in charge, Helen Co. also must report. So Helen Co., which is a corporation, must report all of its executives. So the president of Helen Co. needs to report. The CEO of Helen Co. needs to report. The COO of Helen Co. needs to report. The CFO has to report. And anyone that has any substantial control over Mike and Harry Co. needs to report. So now they all have to report. So now just from yours and my simple two-person LLC, because somebody else, now we can have a manager, we can have someone who's a 1% owner but has control. Whoever has control needs to report. And in Helen Co., there's a board of directors. It's a corporation, and the board of directors has the ability to remove and replace the executives. So if the board of directors can remove and replace the president, which they traditionally can do, then every member of the board of directors must report as well.
Wow.
Ugh. And it gets better. It's like an infomercial. There's still more. So now, Mike, you and I talked, we talk about trust. We talk about lots of things. I would tell you, Mike, I don't want your 50% ownership interest in the LLC to be held by you or your spouse. It should be held by your living revocable trust to avoid probate, surrogate court, and all the reasons that we do for basic and advanced estate planning.
Okay.
We know that's critical. So now, although your trust, Mike, was not a reporting entity, it now owns 50% of Mike Harry Co. LLC, a reporting entity. So now, again, drilling down as to who owns it, does your family living trust, Blue Sky Living Trust, have to report? The answer is yes. Who needs to report? Who created the trust? Who the trustees of the trust are? Who the beneficiaries of the trust are? Who the trust protectors might be? And whoever has power in the trust to move or control a trust asset. And in some trusts that we do, and asset protection trusts and dynasty trusts and more advanced estate planning trusts that we do every day of the week, these could get who has the power of distribution, who has the power to remove and replace trustees. You can have 4, 5, 6, 7 highly talented people that are involved in a trust arrangement. All of them are reporting entities as well. So from our simple two-person, we're now up to about 35 reports for that one. And we got 90 days to do it. But there's still more. For new entities that are filed after January 1st, 24, this does not apply to the old entities. For new entities that are filed, we have another called the company applicant. Okay. So let's say that Helen is my paralegal, and she now files the paperwork with the Secretary of State of Connecticut for Mike and Harry Co. So the person who files also has to report. So Helen has to report her name, her home address, her identifying documents as well. In addition, if I'm the attorney that made the recommendation, I'm the supervising attorney for Helen, my paralegal, I need to report as well. So the company applicant, me, Helen, and Helen, both you and I as owners, the company itself, and anyone that has any interest or control, and if it's held in a trust, all the aspects of the trust. So
Wow.
let me kind of take it through for all of the Vistage people. Let me give you a classic example of how this works. We were talking to a Vistage chair, several Vistage chairs in Texas. And Texas, what's all the matter? They're all in the oil and gas business. And everyone's in oil and gas in Texas, or in cattle ranching, but we'll use oil and gas for the moment, you know. And so now so when they drill an oil well, all right, it's a risky business. They can blow out, they can catch on fire, they can pollute things, people can get injured, on the well site, very, very, wildcats. They call all kinds of issues. So every single well that's drilled is an individual LLC for asset protection purposes. So a liability at that well stays at that well. So that well is a reporting entity, AB well number one LLC. All right, has to report its address, it's identifying numbers. Now, when people invest, so let's say Helen, you and I decide that we're going to invest money in that oil well. All right, we want to make some money when drilling that well. Helen, you and I are not going to invest individually. There's too much liability. So Helen forms an LLC, Harry forms an LLC, Mike forms an LLC, and those three LLCs are the owners of the LLC that's drilling. Every one of those LLCs and all of its owners need to report as well. Now, since Mike, Harry, and Helen, this is not something that we do all the time. So we're maybe involved with 30, 40, 50 different wells that are involved. So we formed a holding company. So you got Helen Co., the holding company that has each one of these LLCs that is an investor in the oil well. So Helen Co. needs to report as well. And of course, for good estate planning purposes, everybody has their stuff in their trusts, whether it be their dynasty trust, children's gifting trust, asset protection trust, living revocable trust, family trust. So therefore, all of the trusts need to be reporting. From a simple scenario of drilling a well, there could be 75 to 80 reporting transactions on one well. And for each transaction that doesn't happen, $591 a day fine. Now, one of the interesting aspects of that, and now, so that's new. New is kind of not so difficult because if Mike, if you and I and Helen, we form a new entity, we know who the owners are. We know that we're going to put it in the trust. We know, who the control is. But remember that the decision of control, what is control, is a legal determination. And when you get up into the estate plan, to your living revocable trust or your trust, there's an awful lot of legal determination of who has power and control that needs to report. So I would strongly suggest, I don't have to list it, that should be handled by a law firm that really has a great understanding of what the ownership and control really looks like under the Corporate Transparency Act. It's one and done, Mike. It's not every year, one time,
Okay.
we get it done. All right. So, and the other thing too is that I think, given the fact that there are criminal penalties associated with this, not doing it properly, willfully, attorney-client privilege, I think, would be helpful for people to do it. It's a bit of a burden and a bit of a cost, but I think, and I'll go through what those costs are in a little while. I think it's beneficial to help get it done. So, but we know when we formed Mike and Harry Co. and we put Helen in charge, we knew what was going on. Now, we go back to the entities that Harry formed, that Mike formed, and Helen formed 10 years ago, 12 years ago, 15 years ago. All right. That may hold real estate, some machines, whatever, some investments, good. If we did some good asset protection planning, nothing's in our own name. We have it in LLCs and trusts, to protect ourselves. Now we need to figure all that out for the pre-existing entities. We need to figure out, and remember what's happened. If they're over a 25% owner and not a minor, they're a minor, they don't have to report. But the moment that they reach the age of majority, they need to report. But for a minor, the parents need to report on behalf of the minor. If someone dies, stuff goes into probate, stuff goes to trust administration, winds up with beneficiaries. We have a change of ownership. We have purchases, we have sales, we have people that have gotten divorced and the spouses don't talk. They don't even know where they live anymore, but they still have an ownership interest in a pre-existing passive business. That all has to get tracked down and get reported. And there are no exceptions. FinCEN has been instructed by Congress that 99% complete is incomplete. Has to be 100% or $591 a day fine. I don't know how this can happen. So there is another bill floating around Congress that's been passed by the House, not yet passed by the Senate, and not yet signed by the President, which is primarily involved with some extensions of time. So at first, we had to report a new company within 30 days. That got extended to 90, but changes. So if Mike, you move out of Connecticut and move to New Jersey, right? And your FinCEN number now, your address and your driver's license is no longer in whack, you have only 30 days to report that change to FinCEN. So you'll keep the number, but you have to report the change. It's 30 days or $591 a day fine. That's ridiculous. And so one of the proposals is for changes to go to 90 days rather than 30 days. And the other part of the proposal is to extend all the pre-existing companies from December 31st, 24 to December 31st, 25 to give us another year to try to bring these companies into compliance. It hasn't passed yet, but it is at least pending. So some of the challenges that we all face together. Now, remember, for pre-existing companies, we don't need a company app. We don't need to know who the lawyers were that recommended it. We don't need to know who the paralegals were that filed it. That's just for new entities after January 1st, 2024. So one of the things that comes about too is that we need to look, and this is an opportunity. Remember, one and done. Once we file our entity, Mike Harry Co., unless it's changed, where we live, ownership, control. We know Helen Co. is not managing anymore, a different company is. We have no further reporting requirements.
And that's a 30-day window to report those changes. You might not even have your new driver's license in that time window.
That is correct. Correct. It's problematic. Now, in addition, where's an opportunity? So it's not just an opportunity. I think for all new entities, new limited partnerships, new limited liability companies, new corporations, in their operating documents, their shareholders agreement and their operating agreements and their limited partnership agreements, there needs to be a new section that's added. It's called Corporate Transparency Act, which says that our company is responsible for making sure that all of its owners and those who are in control of our company are filed with the United States Department of Treasury and FinCEN. And if you're not, you cannot be a member of our company. And if you are, you can get thrown out of a member of our company. So we can't have any nebulous people floating around because there are no exceptions to this. So we need to have language that all of us agreed to. If we're a third, we all agreed to comply by the act if you want to be a member of our company. For all pre-existing companies, it takes an opportunity to revisit. It's a good time to take inventory. The shareholders agreements, limited partnership agreements, limited liability company operating agreements, and add new language into them covering the Corporate Transparency Act, and also giving a chance for those documents to be updated. They are woefully, people have died, people have given stuff to kids, people have turned around and give stuff to ex-spouses, people have new holding companies and new trusts that hold their long time. The company's been about 15 years, and 15 years, they never changed the corporate documents, and they're woefully out of date. So it's a great time, since we have to bring it all under compliance with the real people that are involved, for everybody to bring their administrative documents up to speed and use that as an opportunity rather than a detriment. I think that's something that everyone should look at. Another detriment that we face is there's an awful lot of data floating around. So now I have Helen's home address, I have Helen's driver's license, I have I have Helen's passport. I know all things about Helen that she may not want me to know. All right, but now I know all that stuff. And so she's transmitting that to the law firm, and then the law firm is then filing that with FinCEN. So we have to protect the data. So you have to make sure that you have secure vaults and portals, that everything has end-to-end encryption. Even when you go to FinCEN's website, they're turning around and telling you, be careful of scam artists and people that are trying to steal identity. It's a great time because it's going to be this mass migration of sensitive data through the cyber system in America. I mean, if anything is ripe for a sensitive data to be stolen, this is a great opportunity for the thieves to do so. So we need to be assured we do that. Now, the AICPA, those are the people that, are basically the organization for CPAs, have told their members, CPAs, do not touch filings for the Corporate Transparency Act. They consider it to be the unauthorized practice of law. Now, everybody can do their own. They don't need to use a law firm. But we have baked in, for example, whenever we form a new entity, we formed probably 200 since January. We bake into our formations compliance with the Corporate Transparency Act for all new entities. And for $595, we will examine every old entity with all of the lattice work, the 50, 60 people that need to comply. And so we would produce a map so that people would know how to comply. And then we have a service for $250 that will actually take all that map, whoever has to comply, and put it into FinCEN. So you can do it yourself. You could sit there on a Sunday in the Byzantine FinCEN website, it do 70 entries. Over $250, you can have a service do it for you. I'll pay $250 and let service do it for me. I have better things to do with my time. But
no argument there.
It's it's an option. So those are we'll call it the issues that we now have with CTA. So I think we want to kind of in my opinion, it's constitutional because we can't even do anything. You're going to do a notary, Mike, you're going to need your address, your driver's license. All modern Western economies in Europe have a version of the CTA. The modern Eastern economies have a version of the CTA, and now we have version of CTA. It has, and if you go to the language that was used by the judge in the Alabama court case, judge said, "Hey, look," he said, "there is some legislation which is really stupid, but it's constitutional." He said, this is noble. Make us safer, right? Make it a safer world for us because people are hiding behind these shell and empty companies. Money laundering and terrorist activities don't occur at IBM. Where they occur is at Mabel and Jane's hair salon, the Connecticut S Corporation in their back room. That's where this stuff occurs. The cartel is not involved, with Apple. The cartel is involved with Mabel and Jane, all right? Because they're using their entity to launder money and to finance terrorist activities. So he said that although noble, not necessarily constitutional, and the question, did Congress have the authority to do this? I think it did. It may have to make some minor modifications along the way to the act. I think that, so for example, if you and I, let's say the three of us, we have an entity, let's say it's an older entity, older, before January 1st, 24. So we got Helen, Harry, and Mike. And Helen calls bullshit. I am not giving that information to the government, just not doing it. And she's willfully saying, I'm not going to comply. I think that's unconstitutional. It's a violate my privacy. I don't want you guys knowing where I live, blah, 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 all that stuff. Helen don't want to do it. So what do we do? So now we have an entity that is not in compliance. And this is important, there are no exceptions. So Congress has told FinCEN that they cannot accept Harry, Mike, Helen Co.'s registration unless it is complete. So if we said, here's Mike's info, here's Harry's info, Helen is unwilling to submit our information, $591 a day fine starts against our company. $591 a day fine starts against Helen, and Helen could be held liable for a felony by causing us not to be able to be in compliance. So Helen, either you're gone from the company, okay, and now how do we get rid of Helen? Do we buy her? She lose her job? It's just awful. I'm not so sure that we, Mike and Harry, should be held liable for Helen's willful decision not to comply. That's her decision. We've done our best to comply. Helen should be the one that's liable, not us. I think that there's some question of constitutionality, at that point that needs to be ironed out yet under the Corporate Transparency Act. So it's not complete, but it's here, and I think it's here to stay. The last thing I want to talk about before we take questions and answers is that benefit and burden. All right. So and this is just my legal opinion. So we are burdening 33 million companies, good law-abiding companies that now have to spend time, do analysis, and in many cases spend money that it's hard to come by today to bring things into compliance. And the hopes behind all this is that this will cut down on terrorist financing, money laundering, and tax evasion. My humble opinion is 33 million firms are going to be burdened, but the amount of it actually cutting back on terrorist financing, money laundering, and terrorist financing is pretty much nil and none. They're criminals are criminals. They'll find a way. They'll use AI, artificial intelligence, to create persons. They will find a way around the Corporate Transparency Act. It's like the old story with guns. You can take away the guns from the good people, then only the bad people, they just get guns because they don't care. So you got a similar scenario that happens here. So that is a concern that I have. And the other concern that I have is the chilling effect when Helen turns around and says, I'm sorry picking on you, Helen, but you're here with the glasses. When Helen turns around and says, I'm not forming a new LLC to hold my real estate. I'll just keep my real estate in my trust because I don't want to give all that information to the government. So now Helen is exposed to landlord-tenant liability to the full extent of her net worth. If Helen has a liability, she'll lose her real estate. All the reasons to have that real estate held in an appropriate limited liability company and all the proper asset protection estate planning reasons to keep it out of probate court and all the reasons to having it structured properly just went out the window because Helen didn't want to comply. So it's a chilling effect on proper asset protection and estate planning because of the Corporate Transparency Act. That we have to guard against. People have to just grimace themselves and say, hey, I will comply. All right. Because the burden or the detriment of not complying could be significant on so many other levels. So you get that. It kind of sets up, like everything else in the country today, this yin and yang between what we should do and then what we have to do, and over-regulation, and it's just difficult. So I think everybody now has a much better perspective of what the Corporate Transparency Act is and what it's all about. So now it's time, Mike, you got questions, and let's go for them.
Yeah, I do. Harry, thank you. Thanks for stepping through all that. It's much more involved than I understood at all before talking to you, so thank you. One, I just want to clarify. A number of my friends have talked about the appeals and the lawsuits and everything, but right now, the way the law stands, this is the law of the land.
That's correct. 100% correct.
So there's some things in Congress that may or may not get through. There's some lawsuits that may or may not be won. There's some appeals, but right now, this is the law of the land.
Unless you are a member of the National Small Business Association plaintiffs in Alabama. That is correct.
All right. The way you've laid this out, one of the things that really concerns me, and I don't know if there's an answer, is just all this information out there from so many people that's going to be subject to all sorts of hacker attacks and everything else in terms of, and from China, from Russia, from wherever. That's a lot of information out there that's going to be potentially at risk if it's not super, super well protected. So that's a real
Well,
concern.
you got protection on two sides, Mike. You got protection on the transmission of the assets through the law firms to FinCEN. Then you also have the United States itself protecting the data from hacker attacks from foreign governments. Because they now have all this information and a database. They hack that database. I mean, they've been able to hack the Treasury Department before, and then they pick up, Helen's address, Helen's home address, Helen's its driver's license, Helen's passport, which they could have gotten, but they would have had to do it much more difficult from 4 or 5 different sources,
Yeah.
maybe from
Putting
watching TikTok,
Yep,
things like that.
absolutely. Putting all that in one place, and then, which is I think it was the senators on just the other day saying the Chinese had infiltrated the U.S. infrastructure from a data standpoint. So, really concerned there. But and that leaves to my.
But that's not a question.
real-
That's a statement.
That's a state. That's a concern. I'm a chair. I get to voice my concerns.
Yes, you do.
But my next question is, because of that concern, because of the timing, because this is the law of the land, but there's so much in progress right now. How do we stay updated on legal and regulatory changes?
Well, a couple of things that are going to come from that. Hopefully, the government has learned that they got to find a way to bring that information to the business constituency. They have not. So it's through things just like you're doing right now, Mike, for your members, that they'll see this, and then you and I will stay in contact, and I will do the best I can, because we get the information as it comes up right away, to get that to you so you can get it to your constituencies. Kind of the deal that I make with you guys.
Harry, as soon as you hear, I'll get
Yeah.
that out to all of my contacts and certainly all my members in doing that. I guess the next question is, given where we are today, what are the actions my members should take tomorrow?
Well, not self-serving, but I would think for most Vistage members that first a determination needs to be made. What do they have to file? Many of them don't. They're under that 20 employees, over 5 million sales. But again, the peripheral companies do need to file, and many Vistage members have that.
And
But
it's all those LLCs you mentioned that I think that raised the concern. The
yeah,
major
LLCs could be corporations, could be a little bit of
Will be fine,
partnerships,
but
doesn't matter.
for
Yeah.
real estate, for boats, for all those things that you might have.
Yeah. So what we do is they should either try to figure it out themselves or engage a firm such as ours, because the firm has to know estate planning, needs to know entity structuring, needs to know CTA laws, and it's federal. So it doesn't matter whether we're in California, we're in Connecticut, we're in New York, or in Vermont, makes no difference. But the issue, and I'm licensed in New York and California and Washington D.C. and other places. So, but the issue is that they should reach out to a firm. It's not that expensive. Engage a firm to analyze their pre-existing entities. Now, if you got existing entities that like I have sitting on the shelf that I haven't used, I formed them a few years, dump them. It's a great time to dissolve them. You don't need them anyway, so you don't have to file them. So it's a cleanup act. So it's a time to clean everything up. And then we would analyze for them this is a pre-existing. New ones, the firm should know what they're doing. All right. If not, reach a firm that knows what they're doing. For the pre-existing ones, we would create who needs to file, the entity, the owners, control, the estate. We examine the estate planning documents, and we're doing that as a bargain for Vistage guys and gals at $5.95 an entity. And then we give them the map. So now they have the 15 filers, and they have also now gotten the information that's needed to fill in the map, address and identifying documentation. And then once we have that map done with addresses and identifying information, then the next step is to just file it on the FinCEN website. They could do it themselves, hire a service to do it. So I have my FinCEN number. I have 12 entities. Have I done all of mine yet? No. Shoemaker shoes. Matter of fact, I was just talking to one of my attorneys that work with me. And I said, "Guy, you got to take care of this for me. I got to get this done. I've just been dilatory to get it done." So you get it done, and it's one and done.
Yeah.
Do I like it? No, I don't like it.
What you're pointing out, Harry, is that my first reaction was, well, I'll just wait till the end of the year, see if any laws change, and then I'll know what to do.
But
if I do that, then we're going to have what's worse than an April 15th rush at the end of the
Yes,
year.
right.
to
And
get all
then,
this stuff done during the holidays when it's not when you want to be doing it.
and not only that, it won't get done. That's the whole point. And it won't be complete. For some, it's easy. It's just, hey, it's, Mike and Harry. We don't have a trust, and it takes 2 minutes and you get it done for our pre-existing entity. But if we don't get it done, when the enforcement begins at $591 a day for each violation with no cap, then like I said, all the poop hits the fan. And then people are going to scream. Now, when that screaming happens, one of two things will occur. It'll be strictly enforced. Well, Congress will go back in and kind of give some relief, giving us that extra year that we really need to get things done. So there's a very
Only if we-
difficult law to comply with.
Only if we use the extra year and just don't sit here for another 12 months and then put ourselves in the same situation.
But
and there's no
human nature
I hear
says that
you-
that'll happen. Yeah.
If I hear you correctly, there's no penalty for filing early. So if I file early now and they extended a year, I'm filed. I don't need
filed.
to, it
Correct.
doesn't hurt, right?
Correct. And there's no cost to file. I mean, there's no cost to go to FinCEN and file. You just people that help you. If you want to engage people to help you, you have some cost. Otherwise, you could do it yourself and go to FinCEN. You get a number, get it done.
Okay.
But no, there's no penalty for doing it. And my best legal opinion is it's here to stay in some form. It's important that law enforcement knows who's behind the shell companies.
Okay. And then, and Helen put the FinCEN website in the chat, I see. So
I
we'll get-
did. I did, and keep that handy. We've recorded today's presentation and we're going to be circulating this to everyone that registered for the event. Make sure to be looking out for this on YouTube, on LinkedIn, share it with someone. This is important information. I just want to thank you guys for your time today. And thank you for Mike for help hosting and bringing this to your network. Harry,
Thank you. My pleasure. And
Got
Harry,
it.
always
Mike,
fun.
great to see you, buddy.
Yep.
All right.
I took notes, Harry. I took
take notes, and
here.
I'm ready. I'm still ready to present on the upcoming estate planning apocalypse and stuff, other things for your group. So we're looking forward to it.
Super. Thank you. We'll
All right,
connect.
guys. Thank you,
All right.
buddy. Thanks, Helen.
Bye for now.
Bye.